Allow me to reintroduce myself. Now tuned into the greatest.
What's up, people, and welcome to the Supreme Decisions Legal Minute podcast. And today, I'm actually going to get right to it because it was something that was brought to my attention that I actually don't agree with, and I'm sure you're going to have a few opinions about it, but at this point, I don't care. Because at the end of the day, it's not my opinion that I'm getting ready to state to you. However, it's going to sound that way because it's going to come from a place that's not necessarily in the means of actual law that I'm going to be spewing at all times, but it's going to come from a place of aggravation because I understand the programming and how they are eliciting points of doing it and wanting you to believe it. Because today it's going to be something that I did a video on probably about 6 months ago, and it's Miranda v. Arizona, 384 U.S. 436 1966. Now, on March 1st, 1966, there was the concluding of a jury on Miranda v. Arizona. The decision came in on June 13th, 1966. So in effect, Miranda v. Arizona went into effect June 13th, 1966. And what it brought about was verbiage that I find hilarious. Because when you talk about Miranda v. Arizona, it's a landmark decision of the United States Supreme Court. The court held that both inculpatory and exculpatory statements made in response to interrogation by a defendant in police custody will be admissible at trial only if the prosecution can show that the defendant was informed of the right to consult an attorney before and during questioning, and of the right against self-incrimination before police questioning, and that the defendant only understood these rights but voluntarily waived them. Now, you know me, I always tell you, if you're going to exercise the right, no matter what it is, it needs to be done in writing. And that's generally what they have you do when dealing with the police. They'll have you waive your rights in writing. They'll have you sign it that you waive your rights in writing. But most of us have no idea exactly what right we are waiving in writing. Or we want to complain to someone and not understand that the complaint itself is baseless because it's not done in writing, because nobody wants to hear your voice. And right now I don't want to hear my voice, but it is what it is. Because at the end of the day, the exercising of any constitutional right needs to be done in writing for the most part. And those that are not written down, because the pen is mightier than the sword, are given up. But the thing that actually got me about this was not the use of statements, because you have the right to remain silent, but most of us lack the ability to do so. But during the interrogation, the one thing you always see in these police shows or this, you have the right to remain silent. Anything you say can and will be held against you in a court of law. You have the right to an attorney. That's where I have the problem at. Because they use the word attorney. Attorney, attorney, attorney. And here's the greatest part about that. Is because me reading through the Constitution, I actually had to go back and read it again. And at no time did I read the word attorney in the United States Constitution. However, it was co-written by several attorneys, but they didn't use the word attorney. Now, again, you understand I did a video regarding about words having power. I always talk to you about the programming, because they want you to believe a certain way. They want you to think a certain way. They want you to feel a certain way. But if I say I'm going to uphold and defend the Constitution of the United States of America, and then I use words regarding it regarding rights, regarding restrictions that do not pertain or are not in the Constitution. Am I really enforcing or upholding the Constitution? Because even the thing that trips me out about this entire thing is the fact that people have come to not even understand the word attorney. They don't understand the meaning of the word lawyer. They don't understand the meaning of the word counsel because they want to lump all three of those together when in fact they are vastly different. They are vastly standish on their own. They are vastly not similar. Because if you look up the word lawyer and you look in any one of your legal dictionaries, and generally I would use first or second edition. Anything beyond that is watered down garbage. And yes, I did say it. If you're looking at something that's a legal dictionary and it's beyond the second edition, you're looking at watered down garbage. And I think I talked about that before, as in the movie Multiplicity. The further away you get from the original, the worse it gets. But in essence, if you look up the word lawyer, the word lawyer means one learned in law. Doesn't say attorney. But it can be substituted with the word counsel, because counsel is someone that is a guide or advisor. So a lawyer is counsel. An attorney is someone that is the member of a fraternity. That's the long and short of it. They're carrying a bar card. That means they paid their membership dues. That's it. It's not that they've done anything, know anything. And they're probably well versed in statutes, codes, and ordinances, and their first duty is not to their client, it is to the court. I'm actually going to do a video on that. But at this time, we're just going to deal with the fact that Miranda v. Arizona states you have the right to an attorney, when in fact that is absolute bull. Because we know they're allowed to lie, but the fact that it's written down, that's the thing that got me. It is actually written that you have the right to an attorney. And the reason why that has me kind of dumbfounded is the simple fact that when we're looking at Supreme Court cases, because you know I always talk about how that is the supreme law of the land, how the United States Constitution stands on that, the supremacy clause of the United States Constitution, the clause of what this nation runs on. Not built, but it runs on. The one thing that police officers and all public servants fall under, they agree to uphold and defend, is right there. Yet, many of them either don't act on it through ignorance, or they're purposely not following it for revenue. So you decide which one it is, because when I look at Supreme Court decisions, and I look at the Constitution's Sixth Amendment, because the Sixth Amendment is a beautiful thing, because it lists out a lot of different things that we can expect. They list out things such as the right to privacy, right to be secure in one's own home, person, and things. But the one thing that actually is beautiful to me is the part of the Sixth Amendment that says to be confronted with the witnesses against him. Because you know me, I always talk about the act of confrontation, because we're in an adversarial system. But when we're talking about this instance of attorney, we're talking someone that is there as an advisor, someone that gives us direction. But the Sixth Amendment just states, and to have the assistance of counsel for his defense. Why didn't it say the assistance of an attorney, or the right to an attorney, it just simply says, have the assistance of counsel. Why? It's because we are our own people. We have the right to defend on our own. We also have the right to the choice of counsel, not the quality. Because we have to make a decision whose hands we're going to put our lives in if we don't know any better. That's our choice, not someone else's. And many of you can be like, oh, well, I got a public defender, or I was given a public defender. It's your choice, because at the end of the day, that public defender is just that, a defender of the public. And what they need to understand is the fact that as a public defender, they are a guide. They are an employee. They must work on your direction or discretion. And Gideon V. Wainwright, 1963, 372 U.S. 335. The right of an indigent defendant in a criminal case to have the assistance of counsel is a fundamental right guaranteed by the 6th Amendment and 14th Amendments. And the reason why I read it like that is because understanding this is a war on the poor. They're going after those that can barely make it by. The reason they're going after those that can barely make it by is because those are the ones that are most inconvenienced. And if they're able to pay, they pay. Why? Because they don't want to deal with the inconvenience. They're easily intimidated. Because the thing is, they're worrying about losing their job. Because remember I told you 80% of America is living paycheck to paycheck. Well, we're going to stop all these extra noises in a little bit, but if you're living paycheck to paycheck, the one thing you don't want to do is lose a paycheck. Because if you lose a paycheck, guess what? Now you become something that you don't want to be, which is instead of a working, productive citizen, you have to resort to something that may be a little against the law, which means you might have to do things that are not above board, let's call it that way. And if you're kind of controlled in that sense, they can generate revenue from it. They know you're not going to fight back. They know you're not going to question it. They know that you don't have time. They know you won't make time. Because they understand this is chess, not checkers. And making moves that are king moves is the one thing that allows the revenue engine to keep rolling. Because if I keep you just above broke, because that's what the job is, just above broke, or just over broke, I control everything that you do around broke. Because once you go broke, you become a criminal. You become the person we're looking for. But the second you're not, that's when we have a problem with it. We're going to give you all this free information where you can go out and get the education that you need, but I'm going to make sure that you don't understand what you're looking at. I'm going to make sure that you're actually struggling to even absorb what's going on because you're just over broke. Now, whenever I use the word attorney, I'm not using it as the pretext of something that is wonderful or great. Because, again, they're actors in concert with the judicial system itself. Very seldom, unless there are actually defense attorneys, are they very good. Because one thing people don't understand is defense attorneys are those that fight the system. And by fighting the system, they have to basically put themselves in a position where they're rejecting the court itself. Because once they become a member of the ABA, they are employees of the court, not working on your behalf, even if you're cutting them the check. so they don't want to go against the machine. But here's where the beautiful part is at. Because Wainwright says you have the right to assistance of counsel, not to an attorney. Even I'm about to butcher this name. Arjun Singer v. Hamlin, ARGERSINGER v. Hamlin, 407 US 125. Oh, excuse me. I don't know what the hell am I looking at. 407 US 25 1973. An indigent's right to appointed counsel does not turn on whether the offense it charged is a misdemeanor or a felony. Counsel must be furnished if the accused faces the loss of liberty. Now again, we understand the word must, but again, we hear the word counsel, not attorney. Now, we have attorney in Miranda because you have the right to an attorney. But in these couple of cases I've given you, they use the word counsel and not attorney. Why is that? Why are they programming you to get an attorney, 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 get an attorney? When in all of their decision, or in the majority of their decisions, can't say all, the majority of their decisions, appointed counsel, appointed counsel, appointed counsel, appointed counsel, appointed counsel, appointed counsel. Because here's the greatest part about that. Chandler v. Freitag, 348 US 3, 1954. He has the right to be heard through his own counsel is unqualified. Now again, when I talked about my people that love to go to these law dictionaries, and again, first or second edition. But if we go into a first edition Black's Law Dictionary, or in a first edition Boevil, or in a first edition Ballantine, unqualified reads as unrestricted. So now if I implement unrestricted, he has the right to be heard through his own counsel unrestricted. So that means I can choose what I want. Why? Because the Constitution safeguards one's choice of counsel, but not the quality of counsel, which is why a lot of these garbage ass public defenders have 100, 200, 300 cases, and they only spend an hour on a case, although the bare minimum for a case is 100 hours, and they have no idea what's going on because they're not working on your behalf. They're not working towards your benefit. They're not giving a shit about guilt or innocence. They're worried about revenue generation and their loyalty to the court. And at the end of the day, the role of an appointed counsel is strictly in advisory capacity. Because even United States versus Gonzalez Lopez deals with the choice of counsel, not attorney. Because when we're talking about those rights and those reasons, even in the understanding that a state cannot exclude a person from the practice of law or from any other occupation in a manner or for reasons that contravene the due process or equal protection clause of the 14th Amendment. Whether the practice of law is a right or a privilege need not be determined. It is not a matter of the state's grace, and a person cannot be barred except for valid reasons. And that's Schwart, SCHWARE versus Board of Bar Examiners, 353 US 232 1957. Because you also have something that I talked about, because the selective incorporation doctrine makes federal law implemented to the states through the 14th Amendment, and they have this thing called next friend, or in some cases, jailhouse lawyer. Because the qualifications are that are, to me, hilarious. Because what most people don't even understand is a person who represents another person who is under disability or otherwise unable to maintain a suit on his or her own behalf and does not have a legal guardian. Because that is the jailhouse lawyer. Because a legal lack of knowledge of law and procedure qualifies as a disability and the inability to maintain a suit on your own. So guess what happens? You go to jail, you get a jailhouse lawyer. Why? Because all they do is sit down and read. They get access to the law library, get to do their thing like that. And the person that they represent is at a legal disability because they have a legal lack of knowledge of law. And the great part about that, especially for someone like myself, is the fact that 90% of Americans have a legal lack of actual law. That includes those that have gone to schools such as Princeton, Harvard, Cal Berkeley, Cornell, because they're studying specifics. Most of them are then transitioned into studying statutes, codes, and ordinances. So the actual application of law leaves them. Now, am I saying that the majority of the people that graduate from these prestigious colleges don't have a law? No. Understand, it's still a small number, because if I say 500 graduated from Harvard, 300 graduated from Princeton and Yale, and another 700 graduated from Cal Berkeley, that's not even close to 1%. So, yeah, I say it's safe to say that there are a good bunch of people that are graduating with the knowledge that's necessary for them to be proficient in the practice of law. But when you're talking about the totality of Americans that are supposedly set to know the law once they become of age, because, you know, you're supposed to know right from wrong because that's what you were taught. But if you don't know what's right and what is wrong, and you're not liable because you're crazy, is that still law? Is that something else? Because at the end of the day, we have the ability to choose if we so want someone else to represent our interests, because it's protected by federal law. And the second part is, you are above the age of 18 and considered an adult, so have no legal guardian, but choose to exercise your legal right to counsel, not an attorney, of your choice, because the Sixth Amendment protects your choice of counsel, not the quality. Because at the end of the day, when you're choosing a next friend, there are guidelines for that. And the biggest guideline is the lack of legal knowledge. And your understanding of process. Because everything that you're doing, legal or otherwise, has a process to it. You may not even like it. And I actually see a lot of people that are unsuccessful doing their own suits because they're looking for ways to circumvent the process. And the one thing that I do know, line by line, precept upon precept, that is the way that I was taught to learn. I'm going to say that one more. Line by line, precept upon precept. That was drilled into me every day. Because no matter what I want to circumvent, because let's say you're doing a math problem. And in my case, I was doing calculus. I always tried to skip a step. It may not have been big. I may have still gotten the right answer, but I can't skip a step every time. I can't skip a step every situation. But if I go line by line, precept upon precept, then I can definitely do that each time, every time, without losing the fact of knowing what's next. I can stay on margin. And that's what happens. A lot of people are trying to circumvent the process by skipping steps and doing things that are unnecessary, or actually, in most cases, giving their hand away. And what you need to do is figure out what it is that you're trying to do. But that becomes something that is learned in law. That's something that is necessary when you are trying to get to a different position. But it's knowing what the process is in advance. And then you will forego your appeal agreement of ineffectiveness of counsel because of not choosing a bar card carrying attorney to represent your interests in that singular matter. Because when you're choosing, it doesn't matter. Because if you make a choice and they don't follow your guide, well, guess what? That's your choice. It's on you. That's your responsibility. Choosing an attorney is one way to kind of skate our own responsibility, and that is the one thing that this country is built on: people skating responsibility. They don't want the responsibility of the actions of themselves. And the thing is that what we're supposed to be here for? Aren't we supposed to be self-reliant, self-sufficient? Are we supposed to be waiting on somebody else to do something for us? Are we supposed to be sitting here and actually wondering the best course of action, or we're allowing somebody else to do that for us because we can't think for ourselves, because we need guidance, because we need something else to persuade us for the most part, or put us in a direction that we have no idea what it is. And understanding, lastly, that this is not an attempt to circumvent the judicial limitations of Article 3 to which the court is operating. The next friend is only acting as a mouthpiece for the real party of interest. And guess what that sounds like? An attorney. Because at the end of the day, what is it that an attorney does? Because they're your employee. Because you're handing them money. Because your boss, when you go to work, hands you your paycheck for doing work. That's what an attorney is. Because a next friend is only a mouthpiece. They're there to say what you are looking to be said. And then we look at a case that actually kind of puts a couple things in perspective. And what I'm going to give you with this is understand, I'm going to give you a little bit more Latin too. But the case or the matter of next friend is the entire regiment of what this is, because again, it's choice. But under that choice, it's something that is built into this country. And then it's King versus McLean Asylum. This is an 1894 case. 1894. Because this was an issue. Because anybody that knows me or have listened to me for any time know one of my favorite people was Abraham Lincoln. And not because, oh, he freed the slave. No, we ain't even gonna talk about that. But Abraham Lincoln was a next friend. He was a jailhouse lawyer. He represented those that needed legal assistance. And he never had a bar card. I'm going to say that one more time. He represented the interests of others and did not have a bar card. He did it in court. He didn't have a bar card. And the whole thing was, he had an understanding. But at the end of the day, he went out and did something. Because he understood even then the system was flawed. people needed an option. They needed a choice, and they chose him. And when you talk about King versus McLean Asylum, stating that in favor of liberty, the court should admit the next friend, and that the aid of a next friend is necessary for the protection of those who, on account of the rigorous nature of their detention or their mental ability, are incapable of acting for themselves. And the rule that next friends must establish that they act for the benefit of the real partisan interests and not merely to promote their own causes. And that line discussing the rule, the next friends must establish that they are acting on the benefit of the real partisan interests and not merely to promote their own cases. The whole thing is, you have a lot of attorneys that do just that. They don't give a shit about the person that they're representing. They don't care nothing about what they're talking about. All they care about is promoting their cause. And at the end of the day, you want someone that cares for you. Whenever myself and Alicia went into our racketeering trial, my grandmother pled with me, get an attorney. Get an attorney. Damn it, get an attorney. And I told her, I was like, Grandmeezy, I love you. I said, but the problem is, me getting an attorney, no one loves me more than I love me. No one's going to act in a means that I need them to act, because no one cares more than I do about me. And the whole thing was, when we won, because when I walked out the door, I was expecting her to be boo-hooing and expecting to not see me ever again in life and all kind of foolishness. But at the end of the day, she smiled. And she said, I'll see you when you get back next week. That was the confidence that I needed. That was the show that I needed walking out that door. And at the end of the day, I had a choice to get an attorney. I had a choice to accept a public defender. Alicia had that same exact choice. He chose otherwise. And we went in there and did what nobody expected us to do, because we behaved in a manner nobody expected us to behave, because they did not understand that we went line by line, precept upon precept. And that was the one thing Alicia would preach to me every day. Line by line, precept upon precept, because there is an order and a right way to do each and everything that we're doing. Because even Worth v. Sheldon, 422 U.S. 490, 1975. Exceptions to this rule have evolved, and the Supreme Court has set out rules for allowing third-party claims. To properly bring such a claim on behalf of third parties, a litigant must demonstrate that she has suffered a concrete redressable injury. Because you remember, when we're talking about standing, it has to be someone that was injured. You know, the injured party. You know, the first part of corpus delicti, body of the crime. She has a close retention or relation with the third party. And basically, you have to know the person that you're dealing with. That's why it's called friend. Everybody that you deal with is not your friend. So everybody that you represent can't be your friend. And there is some hindrance to the third party ability to protect his or her own interests. And again, when we talk about hindrances, we're talking about things such as a legal lack of knowledge of law and procedure qualifies as a disability, and the inability to maintain a suit on one's own behalf. Because that was even re-edified in Edmondson v. Leesville Concrete Company, 500 U.S. 614, 1991. Because at the end of the day, we have the ability to make conscious choices on our own behalf. Because even Whitmore v. Arkansas, 495 U.S. 1490, 1990, held that the 8th and 14th Amendment do not require a mandatory appellate review of death row cases, that individuals cannot file cases as next friend without a prior relationship to the appellant. Because again, everybody that you represent is not your friend. So just because you're looking to do something on behalf of someone else does not make you next friend, does not make you a friend. And the biggest part of that, those are the only two requirements, that you actually know them. And that you're not trying to do something to push your own cause, but that you definitely are learned in law. And understanding that even when you're talking about something as simple as the right to an attorney, understand you do not have a right to an attorney. You have the right to counsel. You have the right to qualified counsel. You have the right to be represented by those that you choose to represent your interests. And no one at the state level can stop that. Why? Because the state does not grant rights. The state cannot take rights away. They can only offer privileges for you to participate in. If you choose not to participate in those privileges, you are not privy to their guidelines. Now, even in U.S. v. Wade, they talk about putting defendants in lineups. And in U.S. v. Wade, it even speaks about the representation of counsel, not attorney, even in stages such as a lineup. You have the right to counsel, or you are entitled to have counsel present during a lineup. That even includes show-up lineups, because one thing that police officers should know is the fact that whenever you are requesting counsel, they can't talk anymore. That even includes if you are in their custody. They have to get your permission to do their job. Because once you say, I'm looking for counsel, or I have counsel, or whatever, it then makes them have to do their job properly. You're becoming a nuisance. Why? Because you're just not flowing into what they want. So, right now, that's what I'm going to give you today. Or should I give you a little bit more? Well, how about this? Only because I love you. I'm going to give you one more. And I'm going to give you something because Arizona is one of those healthy states. Just like Ohio. They give you a lot of precedents. And the one I'm going to leave you with is Edmonds v. Arizona. 451 U.S. 477 1981, which held that once a suspect requests counsel, the police and or prosecutor may not subject that suspect to further interrogations until counsel is made available. This is the same state that stated you had the right to an attorney, but then turns around and says once a suspect requests counsel, they can't even talk to you until counsel is made available, not attorney. So understand the realism of what it is that being attempted to be thrown onto you. Understand what it is. Words have power. Understanding whenever they're using the word attorney, they're not talking about something for your benefit, because an attorney is not there to benefit you. An attorney, unless you choose them, is an employee. But their first guise is not for their client, it is to the court. All of them in there have bar cards. All of them are members of the same club. You have the choice to represent your own interests. You have the choice of counsel, not the choice of attorney. Make your choice. Understand your choice. Live with your choice. Don't allow somebody else to choose for you. And that's all I got today. I love you guys. Keep donating. Venmo, Cash App, and Google Wallet. And let's keep going. Let's keep growing. Talk to you soon.
The shaking colossus.